that there's no judicial review, no process required, no remedy available, very low bar for cause that the president alone determines, I mean, that would weaken, if not shatter, the independence of the Federal Reserve that we just discussed.
This is not a policy dispute. This is a power grab with a price tag. The president's lawyers walked into the Supreme Court and tried to buy the Federal Reserve with a legal theory that turns independent into a decorative word and turns for cause into whatever the White House says it is that morning. The immediate consequence is already here. Markets don't need a final ruling to feel instability. They just need to see the threat and the attempted precedent tested in public, in real time. Picture the scene, the courtroom warm, the winter air outside biting, and inside the highest bench in the country being asked to bless something unprecedented, remove a sitting Federal Reserve governor. Not because a governor took a bribe in office, not because a governor sabotaged the institution, but because the administration wants the ability to declare cause unilaterally without a real evidentiary record, without a real process, without a real check. The shock is not the allegation. The shock is the machinery of removal being presented as a one-man switch. And the stakes are not abstract. The administration is targeting Lisa Cook while keeping Jerome Powell in the frame. Because this isn't only about one seat. It is about the message to every official who is supposed to stand between political appetite and monetary policy. The case is Trump versus Cook, but the real name of the fight is control versus independence. Lower courts blocked the attempted removal and kept Cook in place while her challenge proceeds, and the government raced in on an emergency posture, demanding the right to execute the firing first and litigate later. Now, a trust reset, brief and clean. I'm not asking you to believe anyone. I'm telling you what the government argued and what the justices signaled in response. The administration came in through Solicitor General D. John Sauer and offered a three-part monarchy. First, Cook is not entitled to a meaningful opportunity to defend herself before removal. Second, the president's cause determination is essentially unreviewable by any court. Third, even if courts disagree, courts cannot effectively restore her to the job. That is not law and order. That is law without order. Watch the conservative justices because the story lives there. When Brett Kavanaugh describes this theory as one that would weaken, if not shatter, the Fed's independence, that is not liberal anxiety. That is institutional alarm from the side that has been expanding presidential removal power for years. When Samuel Alito highlights how thin the record is, he is not switching ideologies. He is drawing a line between executive power and executive improvisation. And when the Chief Justice pushes back on the claim that courts cannot review the president at all, you are watching the court feel the blast radius of the authority it has been handing out. Here is the hook again, because repetition is the point. This is not about one person. It is about whether the president can convert for cause into for my convenience, and whether the court will allow that conversion to reach the one institution that stabilizes interest rates, credit, and expectations. Imagine a Jenga board labeled economic credibility. You can pull blocks from plenty of agencies and the tower wobbles quietly. You pull blocks from the Fed and the wobble becomes the headline, the bond spread, the mortgage rate, the layoff notice. And this is happening inside a broader pattern, the normalization of enemies list governance, where investigations, referrals, and removals are framed as justice, but function as leverage. Picture the pressure stack, legal claims at the top, political vendetta in the middle, and financial tremors at the bottom. Even the optics were defiant. Cook in the room, Powell in the room, the targets present as the government argues they are effectively disposable. That visual is the entire strategy. Intimidate the institution by putting a price on its independence for Wall Street watching closely. The legal hinge in this case is not subtle. It is for cause. And everything the administration wants depends on hollowing those two words out until they mean nothing. The Federal Reserve Act allows removal of governors for cause, but it does not hand the president a magic marker to write the cause after the fact on a napkin and call it constitutional. The administration's move was to treat cause as a low bar defined solely by the president, and then to insist the courts have no power to examine whether the bar was met. That is the kind of argument you make when the facts are weak and the ambition is strong. Zoom in on what the justices were actually reacting to. The government was not just defending a removal, it was defending removal without procedure. no meaningful notice, no meaningful opportunity to respond, no neutral fact-finding. The allegation, framed as mortgage fraud, sits largely outside her term of service, and the court's questions expose the obvious. If the supposed misconduct predates the appointment, you are not policing an official's performance, you are weaponizing a dossier. That is why the lower court's due process reasoning matters here and why the government tried to bulldoze past it. Due process is not a courtesy. It is the barrier between accusation and punishment. The administration tried to argue Cook was not entitled to an opportunity to defend herself against the charge before removal. That is a direct collision with the Fifth Amendment logic the district judge relied on when keeping her in place. And the emergency posture makes it worse, not better, because the government wanted to flip the default, fire first, litigate later, and, crucially, keep the seat vacant or filled while the courts talk. In an independence fight, time is the weapon, and that weapon only works if courts are barred from freezing the status quo. That brings you to the tool the government hates, the preliminary injunction. A preliminary injunction is not a final victory. It is the judiciary saying, we are not letting the executive create irreversible reality while we decide whether the executive acted lawfully. Sauer's briefed position and his posture at argument pushed a radical claim. Courts cannot reinstate a Fed governor through an injunction and maybe cannot compel reinstatement even after final judgment. Translate that into plain power. The president could lose in court and still win in the world. A right without a remedy is a right with a funeral. The justices know the remedy question is where systems die. If a president can make a removal unreviewable and can make reinstatement impossible, then independence is theater. Kavanaugh's line of questioning did not just nibble at doctrine, it lit up the end game. A president firing anyone on a board designed to resist White House control with no meaningful process and no judicial backstop. That is why he used the language of shattering. He was describing the institutional physics. And this is where the administration's argument exposes its own hypocrisy. The same court that has been giving wide berth to presidential control over other independent agencies is now being asked to make the Fed just another agency. But the Fed is not just another agency. It is the anchor for expectations. It is the line between politics and money creation. That is why the conservative bloc sounded like people who suddenly realized their earlier precedents built a monster, and the monster is now reaching for their wallets. Call it ideology meeting consequence, call it doctrine meeting markets. Either way, the law here is not academic, it is a fuse. And notice what the government did not want to litigate. The definition of cause in this statute applied to a Fed governor. Once a court measures cause against evidence and fairness, the removal stops being a decree and looks like pure retaliation. That is why the administration sprinted toward unreviewability. Escalation is not a mood here. It is procedural. The administration already lost where it mattered first. In the lower courts, where a district judge kept Lisa Cook on the job, and an appeals panel refused to lift that protection. That is not Trump fighting the system. That is the system doing the one job it still knows how to do: stop an executive from turning a contested firing into a done deal. So the administration went upstairs fast, asking the Supreme Court to bless the removal pathway on an emergency basis. And in the Supreme Court, you could hear the rejection forming, question by question, from justices who do not reject this administration easily. They were not debating whether presidents have power. They were debating whether this particular claim is too greedy to survive. Kavanaugh's skepticism was surgical. A president alone decides cause, no judicial review, no process, no remedy. Alito's skepticism was brutal. Where is the evidence in the record that this dramatic cause even exists? Sotomayor's skepticism was categorical. No Fed officer has ever been removed. The unprecedented nature is the president's act, not the governor's. Notice the pattern? This court has been willing to let presidents remove officials in other independent agencies, and that willingness taught the executive branch a lesson: push further. So the executive pushed further, it pushed into the central bank, it pushed into the institution that markets price into everything. And suddenly, the same conservative instinct that enjoys executive power also fears the collapse of a stabilizer. You could feel it in the tone, not moral panic, but risk management. Because the administration's position does not just remove Cook, it rewrites the job description for every Fed governor. If removal is effectively unreviewable, then every vote becomes a political vote. Every dissent becomes a personal risk. Every rate decision becomes a loyalty test. That is not independence, that is hostage governance. And once you understand that, you understand why the government tried to deny the courts the power to reinstate. Because reinstatement is the only deterrent that matters. Without it, the president can fire, suffer a ruling months later, and still get the immediate outcome. Silence now, compliance now, fear now. This is where the story turns from legal to political without changing the subject. The administration is not merely testing doctrine, it is testing institutional nerve. Cook shows up and stays on the job. Powell shows up and sits in the same orbit. The targets remain visible. The administration remains insistent. The court hears king-like claims, and the court knows exactly what it is being asked to normalize. The longer the case runs, the more the threat becomes a tool. Signal to the Fed that resistance will be litigated, investigated, and financially priced. And here is the escalation in plain terms. Repeated for effect, the administration wants the power to accuse, the power to remove, and the power to make the courts irrelevant. Accuse, remove, immunize. Accuse, remove, immunize. That is not accountability, that is control. That is how independent boards become obedient boards. That is how an independent Fed becomes an independent Fed in quotation marks. A headline prop while the White House holds the strings. The justices heard it, and you could see them measuring whether they were about to sign off on the demolition of a century-old design. Now watch the public image the administration is selling. A cleanup, a standard moral crusade against alleged misconduct. Then watch the reality in the courtroom. A record too thin for certainty, a process too thin for legitimacy, and a remedy too thin for the rule of law. This is the image versus reality collapse. When an administration builds a catalog of targets and wraps it in enforcement language, it is not cleansing government, it is conditioning government. Condition the independent, intimidate the resistant, and normalize the idea that policy disagreement can be recast as cause. Humiliation in this context is not about personal insult, it is about a legal posture being stripped naked in the one room where posturing does not survive. The administration arrived with the swagger of inevitability. Remove her, no hearing, no review, no remedy, and the bench treated it like what it was, a demand for deference so absolute it becomes submission. When a government lawyer is forced to defend a world where the president can decide cause alone and courts cannot say otherwise, that lawyer is not making an argument, he is confessing an ambition. Look at the collapse of image versus reality again. Slower, because this is where the public gets fooled. Image, we have facts. Reality, justice is asking whether the key documents are even in the record. Image, this is simple cause. Reality, a judge pointing out the conduct is alleged to have happened before the appointment, turning cause into retroactive punishment. Image, courts are meddling. Reality, the judiciary is the only thing preventing the executive from creating irreversible harm while litigation unfolds. The administration tried to sell order. The court kept circling back to process. And then there's the most revealing move, the attempt to eliminate the remedy. It is one thing to argue the president can remove. It is another thing to argue a court cannot put the official back, even if the removal was unlawful. That second move is where the mask slips, because it admits the real objective is not justice, it is leverage. If you can fire and the courts cannot restore, the president holds a one-way weapon. That is not the rule of law, that is the rule of damage. Now we hit the options breakdown, and every option is bad for someone, which is why this case is so combustible. Option 1, the court accepts the administration's theory. That shreds the Fed's independence because every governor becomes removable at political speed, with political cause, under political pressure. Option 2, the court rejects the theory and draws a special line around the Fed. That protects the Fed, but it exposes the court's own recent project, expanding presidential control elsewhere, as unstable and opportunistic. Option 3, the court punts, leaving the injunction in place and sending doctrine back down. That preserves Cook for now, but it leaves the threat hanging, and the threat alone can move markets. Option 4 is the quiet disaster. The court narrows the case on technicalities, leaving a roadmap for the next attempt, a different allegation, a different record, a faster procedural strike, the same destination. And because this is the Fed, the destination is not only political control, it is financial control, control over expectations, over rate policy, over the cost of borrowing, over the temperature of the economy. In other words, control over the thing every politician wants and no politician can be trusted to touch. So the humiliation is institutional. The court is being forced to confront the monster it helped create. It gave the executive a wider berth in other areas. And now that berth is being used as a runway toward the central bank. You can hear it in the tone of the conservative questions, not sympathy for Cook, but fear of what happens if this logic becomes a precedent. Precedent is a trap. Once you build it, the next president uses it. Once you normalize it, you cannot unnormalize it. Unnormalize, and the court heard the economic side. When justices worry aloud about market stability, they are acknowledging how confidence becomes contraction because markets punish hesitation hard. Reuters described the concern. This kind of politicization can carry recession risk because it attacks the mechanism that signals steadiness in crisis. That is why the Fed is treated like a bridge too far. Not because the other firings were harmless, but because this firing threatens the bloodstream. Money tightens, credit tightens, layoffs follow, and the political class pretends it was inevitable. Here is the rule of law frame stripped of slogans. An independent central bank is not a luxury item. It is a constitutional safety valve created by statute and protected by norms because politicians are tempted to turn monetary policy into a campaign tool. That temptation is permanent. That is why For Cause exists, not to pamper officials, but to prevent the executive from converting independence into obedience. If the president can define cause alone, then cause is not a standard, it is a label. If courts cannot review, then law is not law, it is permission. Now, widen the lens to institutional fallout. The court can sense the effects because they are arriving in public. Every independent agency that has watched removals elsewhere has learned the lesson. You are only independent until you become inconvenient. Every market participant has learned the next rate decision might be priced through the filter of political retaliation. And every politician watching has learned the dangerous lesson: if you can threaten the Fed, you can threaten anything. This is why the court's skepticism matters. Reuters and other coverage described a bench, including conservatives, appearing reluctant to back the unprecedented firing. SCOTUS Blog's read was similar. The court seemed inclined to keep Cook on the job while litigation continues. That is not a full victory for independence, but it is a refusal to hand the president the blank check he demanded today. The administration asked for king-like authority. It got judicial side-eye. But do not mistake skepticism for peace. The political pressure does not stop because the court looks wary. It mutates. If the administration loses outright, it will frame the decision as sabotage, and it will look for other levers: investigations, referrals, public shaming, personnel churn, to keep the Fed on notice. If the administration wins, even partially, the signal is immediate. Independence is conditional, and the condition is loyalty. Either path corrodes trust, and trust is the Fed's invisible asset. And the financial pressure does not wait for doctrine to settle. Picture the chain reaction. A credible Fed anchors expectations. Anchored expectations keep borrowing costs from spiking. Stable borrowing costs keep businesses planning. Planning keeps jobs alive. Now picture the reverse. A Fed that looks politically capturable, rates that look politically negotiable, and a bond market that demands a premium for the risk of improvisation. That premium is paid by households in mortgages, by small firms in credit lines, and by workers in layoffs. That is why this case is not inside baseball. So here is the inevitable ending, and it lands no matter which party you vote for. The era of presidents testing the limits of independent institutions is not coming. It is here. The Supreme Court can refuse this particular blank check, and it likely will, because even this court understands what happens when politics grabs the steering wheel of money. But the blueprint is now public, and independence survives only by being defended again and again in courtrooms like that warm room in January. And the institutional fallout is not confined to the Fed. When the executive branch argues that its decisions are unreviewable, it is not just picking a fight with one governor, it is picking a fight with Article 3 itself. Courts become advisory, injunctions become suggestions, rights become press releases. That is the same logic that spreads from one case to the next, from one agency to the next, until the country is governed by enforcement first and adjudication never. That is why even conservative justices flinched at the scope. Expect the next beats to be fast. A final ruling is expected by the end of the court's term. Until then, Cook stays, the injunction holds, and the administration keeps signaling it can try again. Watch the repetition. It is conditioning. When the court speaks, the message will be simple. The law binds the powerful, or the powerful have climbed above it.